Hello, everyone. Welcome to Court with Krissy. What is better than watching one defendant fail in the courtroom? That would be watching two. First up, Mr. Pro Se brings a motion to try and disqualify the judge from his case. And then, the next defendant really wants a new court-appointed attorney. Wait until you hear his reason why. I hope you like it. Court with Krissy is now in session.
This is Jam Exploration versus Matthew McPherron.
Yes, I just need to have my client come on in. He's in the waiting room, Judge.
All right.
Yes, Your Honor.
Is Mr. McPherron here?
Yes, Your Honor. Can you hear me?
Yes, I can.
Thank
All right. This is a motion to disqualify me as a judge on this. Mr. McPherron, I can't remember if I told you this at our last hearing. You just heard some discussion about it. I'm not going to be the judge here after December 31st. Judge-elect Hesselink will be taking over this position at that time. But right now what's in front of me is a motion to disqualify me. I'd like you to briefly argue your motion. I'll hear Mr. Blumberg's response, and then we'll see where we are. So, well, Mr. McPherron, go ahead.
Yes, Your Honor. One thing Mr. Blumberg and I can agree on is that I would like for you to also be extended to 75, extend the age. So I've had more than
this case probably wouldn't be done by then anyway. But
thank
go
you.
Ahead.
What we have here is I appeared before your court in 2019 on two separate cases. One on June 3rd that was dismissed, and that following day, the plaintiff in that case, and which was at the time being represented by the Otsego County Prosecutor's Office, filed a trespassing and a PPO complaint against myself, and claimed in that, which I submitted to you, the report, that there was a court order out of your court that you told me my easement doesn't exist. And that pertains exclusively to parcels 15 and 16, which Trooper Wright refuses to turn over that documentation of the court order. It's listed in his audio. He's threatening me with arrest. And then the prosecutor's office has used this report several times in court cases and personal protection orders. And as also Mrs. Guyana was charged with filing a false police report in 2020, and they cited Trooper's Wright's report again. And under Brady versus Maryland, I'm entitled to my documentation, and what Trooper Wright, Otsego County Prosecutor's Office, in the state of Michigan don't agree with what Jam Exploration sold me.
Okay, let me hold on a minute. Let me interrupt you for a minute. But this is a motion to disqualify me, whether what you're saying is right or wrong.
Correct.
And I don't take anything personally if you're asking me to disqualify myself. Why do you think I should be disqualified from this case?
You are my Trooper Wright claims to have a court order that parcels 15 and 16 are that an easement doesn't exist. What was sold to me and what's recorded at the Register of Deeds office, and you're my main witness to say there's no court order. I mean, and there's no court. It's if Trooper Wright claims
without getting into that, attorneys know, and I'm not castigating you at all or saying this, but a court doesn't speak from the bench. Court speaks to its orders. If there's orders in a court file, I'm not going to be aware that they're there. A court clerk isn't going to be aware they're there. They could look at the court file and see if there's there. But basically, you're asking that I disqualify myself because you believe I may know something about a court order that affects this case. Is that?
Yeah, so what we have here is, I notified Mr. Blumberg of this over the summertime, is we are taking this to a federal courtroom.
Okay, hold on. That doesn't matter. Right now, it's just there's what's in front of me is a landlord-tenant case.
Yes, sir.
And I'm being asked to disqualify myself. Mr. Blumberg, your response to the motion to disqualify.
Judge, I'm not finished. We can't mediate because I don't know what actually I'm trying to purchase.
Okay. Sure, I understand, but the only issue is whether whether I am disqualified from the case.
Correct. And future Judge Hesselink was my attorney at this time, and
right now this is nothing to do with Judge Hesselink.
Yep.
At all. This is just
Yep.
me.
Well,
So,
we will recuse him as well. He will be a witness.
well, you know, recusing isn't an automatic thing. It's a motion, as you know, and you filed a motion.
For sure.
I'm going to rule on it, but I'm going to hear Mr. Blumberg's position.
Well,
And in a way, it's kind of moot because I'm not going to be on this case in a matter of, like I say, 5 weeks.
the clerks, when the executive branch says they have a court order, your clerk's office should produce that court order.
Well,
And
this assumes that such a court order exists, but that's not the issue right now. And I don't want to get into that. All I want to say last time, is before me right now is the issue of whether I'm disqualified or not.
Yeah.
That's it.
Yes. Do you have a court order for any of these properties, Your Honor? Which would
But right now, I have no idea how to answer it. I'm not going to answer it. Right now, I've heard your position as to why I should be disqualified. Mr. Blumberg, your position?
Judge, you asked me and I prepared and filed a brief at length outlining the impropriety of this motion. Okay. So the first issue is this timely? And clearly it isn't. MCR 2.003 C1A requires that upon filing a basis for a motion to disqualify, the moving party has 14 days from the date of that discovery to actually file the motion, which he didn't do. He's already indicated that this is based on some prior ruling made years ago. So one, it's untimely. And two, the case law in Michigan is replete. Prior rulings by the court, even if they are contrary to the interests of the moving party, that's not a basis for disqualification. It is incumbent upon the moving party to demonstrate actual bias, which is not a very low standard, it's a very high standard. There's nothing in any of the things filed by Mr. McPherson that would give the court grounds to disqualify itself.
Your Honor,
Mr. McPherson, don't interrupt. Don't interrupt. Let Mr. Blumberg finish.
So again, the motion is untimely, and more importantly, there's not been any demonstration of actual bias on the part of the court. That's the requirement for a recusal.
All right. Mr. McPherson, remembering that the only issue is whether or not I should disqualify myself, not whether an order exists or whether you have the right to the property or Mr. Blumberg's client does. That's not the issue before me right now. Let me finish, then I'll give you a chance to speak. The only issue is whether or not I should disqualify myself. That's it. So do you have anything to say in response to what Mr. Blumberg said?
Does Mr. Blumberg agree with Trooper Wright? And if so, then he doesn't agree with what his client sold me, and that's fraud.
Okay, you're going off on a tangent. That has nothing to do with whether or not I should disqualify myself.
Well, then I guess I also have the 14th Amendment to the right to due process in my evidence, and your court clerk should have that evidence. And I would request that. I can't articulate and litigate without my evidence. And I think I have the right. There's
always a possibility that such a document does not exist. The court, listen, court files are public records.
Yes, sir.
Anybody with reasonable notice can see what's in the court files.
Mm-hmm.
But that's not, hold on, that's not what I'm addressing right now. All I'm addressing is whether there are grounds to disqualify me. Believe me, if I was going to be on the bench next year, I'd probably be delighted to disqualify myself from a case like this because it's going to get murky. And I don't mean any reflections on anybody. Generally, if I'm asked to disqualify myself from a case, my instant answer is yes.
Well,
but I'm not. I can't. Mr. Blumberg is correct. There are no grounds to disqualify me. So that's where things stand. But realistically, two things. You have the right to appeal that decision, but whether or not you decide to appeal that decision or basically to ask it to be considered by a chief judge, which is a circuit judge in this case,
right?
It's going to listen. It's going to be done. It's going to be done. In one sense, you'll be granted because I'll be disqualified as of December 31st. This case is never going to go to trial before December 31st. But I'm signing an order, and Mr. Blumberg, I'll prepare it, that denies the motion.
Your Honor, my next question would be, now that the courts are aware of the actions of Trooper Wright, are we allowing Trooper Wright to continue this action?
Okay, all right. See, right now you're asking me something that is not before me. I have not disqualified myself, but there's other things you may or may not have, and I'm not saying those are the right things to do or not the right things to do. It's not for me to make that decision. Basically, you have, and I can't remember, Mr. Blumberg, you may know, does he have 14 days or 21 days to, I forget which?
I think it's 14 to ask for a de novo review of your decision.
Right,
Yeah.
and so you can do that if that's what you want to do, sir. And I'm not going to do anything on it for 14 days, and by then it's going to be so close to Christmas, court doesn't do much, that there it goes. I mean, and I'm not ruling on anything else that you said.
Correct.
I'm not.
We were just trying to bring it to the court's attention because also the fact that, like I said, my previous attorney at that.
Okay.
Yeah. Yes, Your Honor.
Okay, so really, there's nothing more we can do today.
Okay.
Thank you all very much.
Thank you, Your Honor. Have a great day.
Okay.
We will go on the record in the matter 24 CF 171, State of Wisconsin versus Ricardo Fairbanks. The state appears through District Attorney James Renicky in person. Mr. Fairbanks appears by video conferencing. We have his counsel, Nicholas White, in person. We're set here today in this matter for a status conference. Mr. Fairbanks, before I begin, you're behind on your attorney's payments. When are you going to be able to get caught up?
On the first Thursday of the month.
So on the 5th, you're going to be able to get caught up because by then you're going to need 3 payments.
Yep.
So that'll be $150. You're going to be able to pay $150 by the 5th.
Yes, Your Honor.
All right. So I'll make note in your file by December 5th, $150 must be paid. Okay.
Regarding that fee, I want to object to my lawyer, and his representation of me. Like to ask the court for a new court appointed
Nope.
attorney.
You don't. Sorry. You don't get to choose your attorney. Or you can retain your own private attorney. You can go pay for your attorney. Mr. White is a very good attorney. He does his job.
Yeah. I asked him to look into issues regarding racial profiling, and he told me to hide my face. You know,
If you want to get into these kind of matters, this is not appropriate, Mr. Fairbanks, and I'm not going to get into that. If you want to hire your own private attorney and pay for it, you can go ahead and do that. The county's not going to fund an attorney or have you be able to pick and choose your attorney. The court appointed Mr. White, who is a very good attorney, and he does a great job. And you're paying a very small fee to be able to have a great attorney represent you for this case with 2 serious felonies and 2 misdemeanors.
Okay, Your Honor.
So if you want to hire your own private attorney, you may go ahead and do that. If you want to have a hearing to have me hear other matters, to have Mr. White withdraw and you to go ahead and get your own attorney or to represent yourself, you may do that.
We can proceed, Your Honor.
All right, thank you. So $150 by December 5th.
December 5th. I got it.
So, Mr. White.
Your Honor, my understanding was that we were going to ask for a plea or sentencing hearing put off until January. I'm not sure if Mr. Fairbanks has changed his mind on that or not.
No.
Okay.
Well, we're going to have a status on December 12th at 2 o'clock, December 12th at 2 o'clock, and we'll see if we'll get a status on if we're going to set it for a plea and sentencing, and I'll know if Mr. White has paid his $150 and to see if where we're going to go from there.
Okay.
All right, thank you. We are adjourned.
That's
Thank
it for
you.
me. Thank you, Judge.